If you just got a speeding ticket, your brain is probably stuck in one of two panic modes right now. Maybe you're thinking, I should just pay this thing and get it over with. Or maybe you're desperately hoping if I just say the right thing to the judge, maybe they'll throw it out. Here's the brutal truth that nobody wants to hear. There is no magic phrase. There is no secret loophole. There is no dramatic courtroom rant that will make a judge ceremoniously tear up your ticket and declare you innocent. That only happens in movies. But here's the good news, and this is what could save you hundreds or even thousands of dollars. There is one specific strategy that works more often than any other argument you could possibly make. And in just a few minutes, I'm going to give you the exact word-for-word sentence you can literally copy and paste into your court documents to give yourself the absolute best shot at getting your ticket dismissed before you even step foot in a courtroom. And in this video, I'm breaking down the top speeding ticket defenses that actually work in real courts with real judges. Not theories, not things people claim worked for their cousin's friend, real strategies that defense attorneys use every single day to get tickets dismissed, charges reduced, and driving records protected. By the end of this video, you'll know more about fighting a speeding ticket than 99% of people who walk into traffic court. You'll understand the system, you'll know what judges actually care about, and most importantly, you'll know the one request that can completely collapse the prosecution's case before it even begins. But before we dive into specific defenses, I want you to completely change how you think about your speeding ticket. Stop seeing it as one solid thing you either beat or don't beat. Instead, I want you to think of every speeding ticket like a three-legged stool. If you can knock out even one leg, the entire thing collapses. Leg number one is paperwork. Did the ticket itself and the legal process hold up to scrutiny? Leg number two is proof. Is the speed evidence actually reliable and legally admissible in court? And leg number three is person. Can you personally get leniency, diversion, or reduction based on your circumstances or your driving record? Now, here's where it gets powerful. I'm going to add what I call the golden ticket layer on top of everything, because each of the defenses I'm about to show you is going to do one of two things. It's either going to help you get that golden ticket, or it's going to help you use that golden ticket as a weapon to get your case dismissed. And I promise you, by the time we get to that golden ticket request later in this video, you're going to understand exactly why prosecutors hate when defendants know about it. Let's start with one of the fastest, simplest ways to potentially get your speeding ticket dismissed with almost zero effort. These are what I call procedural strategies, and they attack leg number one of that stool, the paperwork and process. Defense number one is beautifully simple. Delay your court case and hope the police officer doesn't show up to testify. Now, this is probably one of the oldest tricks in the entire traffic court playbook. And yes, despite what some people claim, it absolutely still works sometimes. Here's why. If the ticketing officer doesn't physically show up to court to testify, and if you're in a jurisdiction with massive court dockets handling hundreds of tickets every week, many judges will simply dismiss your case outright. No officer testimony means no evidence. No evidence means no conviction. But here's the reality check you need to hear. Some judges, especially in smaller jurisdictions or in counties that really care about traffic fine revenue, will allow the police officer to reschedule and come back another day. They'll continue the case instead of dismissing it. So you need to treat this strategy more like playing a slot machine at a casino. It's a possible payout. It's definitely worth trying, but it is absolutely not guaranteed, and you should never rely on it as your only defense. That said, delaying your case strategically can buy you extremely valuable time to both request and actually receive what I'm calling your golden ticket, discovery. Discovery is all the evidence the prosecution plans to use against you. And we're going to talk about exactly how to request it in just a few minutes. If you already have a legitimate scheduling conflict, maybe you have a pre-planned vacation, maybe you have a medical appointment, maybe you have a work obligation that was scheduled before you got the ticket, simply ask the court politely and professionally. You can say, Your Honor, I'm respectfully requesting a continuance due to a scheduling conflict on the current court date. Most judges will grant reasonable continuance requests, especially if it's your first request. But here's the critical warning. Make absolutely certain your request to reschedule is officially approved by the court before you assume anything. Double check, triple check, get it in writing if possible. Because if you simply don't show up without getting approval, you're not going to win, you're going to lose automatically. The court will enter a guilty judgment against you in your absence. You'll owe the full fine plus additional fees and court costs, and you might even have a warrant issued for failure to appear. Don't be that person who shoots themselves in the foot before the fight even begins. Which brings me to defense number 2, and this one can completely kill your ticket if you get lucky. Look for specific errors on the actual citation itself. Now, there are 2 distinct categories of errors you need to understand. Category 1 is what lawyers call harmless errors. These are things like minor misspellings of your name, small differences in describing your car's color, tiny typos in the address. Harmless errors like these won't get your ticket dismissed because judges usually allow officers to correct them, or they rule that the errors don't affect the validity of the charge. The ticket still clearly identifies you and the alleged violation. But then there's category 2, fatal errors. These are the mistakes that can actually kill your case dead in its tracks. We're talking about things like the wrong person being named, the completely wrong location of the alleged violation, the wrong date or time that makes the charge impossible, the wrong statute or law being cited so you're technically not even charged with speeding, or the wrong court being listed so the case is filed in a court that has no jurisdiction over the matter. If the ticket is sloppy and contains these kinds of major errors, there's actually a very good chance that the police officer's evidence is equally sloppy. Usually, sloppy cops do everything sloppily. Their notes are bad, their procedures are bad, their testimony is bad, everything is bad. So what do you actually do if you find errors? First, photograph the ticket, make a clean, clear digital copy of every page, then circle or highlight anything that is objectively, factually wrong. Now you're equipped to handle this in front of the judge. When your case is called, you stand up and you say clearly and calmly, "Your Honor, I believe the citation is defective because the identifying information is materially incorrect." Then, and this is critical, you stop talking. Just stop. Hand the ticket to the judge or hold it up if you're at a distance. Let the judge look at it. Let the silence work for you. If the judge agrees with you, your case might get dismissed right there. If the judge disagrees and says the errors are harmless, that's fine too, because it's still an argument you may be able to preserve and make to a jury if you decide to take this case to a full jury trial. Which brings me to defense number 3, and this one is technical but extremely powerful if it applies to your situation. Watch out for jurisdiction issues. If the police officer who ticketed you was operating outside their legal authority, or if the ticket itself lists a violation location that is outside the officer's jurisdiction, this can be an automatic fatal error in many states. Why does this matter so much? Because jurisdiction issues don't just affect whether the officer had authority to write the ticket. They also affect which court holds the evidence, which agency has responsibility to provide proper records, and whether the entire prosecution is even legally valid. So what's your defense here? It's actually quite simple in concept. You're directly challenging jurisdiction. You stand up in court and you say, "Your Honor, the alleged violation location as written on this citation is outside the issuing agency's territorial authority." But here's the key. You cannot just claim this without proof. Bring a map. Bring a printout from Google Maps showing exact boundaries. Bring documentation of the police department's jurisdiction limits. Bring city or county boundary information. Show the judge objectively that the location on the ticket is outside where that officer has any authority to enforce traffic laws. If you're right and you can prove it, your case gets dismissed. If you're wrong, you haven't hurt yourself because you haven't admitted to anything about your actual driving. Which brings me to defense number 4, and this is one of my absolute favorite strategies if your jurisdiction allows it. It's called trial by written declaration, and it's devastatingly effective for one simple reason. Most police officers absolutely hate doing paperwork. Here's how this works. Instead of appearing in court in person, you submit your entire defense in writing. You write out your arguments, you attach your evidence, you file it with the court. Then the police officer is required by law to submit their response in writing as well. They have to write out their testimony, explain their evidence, and file it with the court by a specific deadline. And here's where the magic happens. If the officer fails to submit their written response, which happens all the time because cops are busy and they forget and they hate paperwork, you win by default. The court dismisses your case because the prosecution failed to present evidence. You never stepped foot in a courtroom. You never faced the officer. You just won because they didn't file their paperwork on time. Written declarations are basically a paperwork battle, and cops absolutely hate doing extra paperwork beyond the basic ticket. Many times they completely forget about the written declaration deadline, and you're declared the winner automatically. So what's your strategy here? First, go talk to the court clerk. Ask them directly, does this court allow trial by written declaration? If they say yes, ask for the forms or the procedure. Some courts have official forms you fill out. Others just require a written statement following certain rules. Make sure you understand the deadline for filing. Make sure you understand the format requirements. Then file your written declaration on time and wait. There's a very real chance the officer simply won't respond and you'll win without ever going to court. But now we get to the absolute most powerful part of this entire video. This is the golden ticket itself. This is the one request that can completely change everything about your case. Pay very close attention because I'm about to give you the specific, exact, word-for-word, copy and paste sentence you can use in your court filings to give yourself the best possible chance at getting your speeding ticket dismissed. Are you ready? Here it is. I request discovery of all evidence the state intends to use, including the officer's notes, the method of speed measurement used, the device's complete calibration and maintenance records, and the operator's training certification for that specific device. That's it. That's the entire move. That one sentence is your golden ticket. Let me explain why this is so devastatingly powerful. If the police and the prosecution cannot produce all of that documentation, the case against you gets very shaky very quickly. The judge starts questioning whether the evidence is reliable. The prosecutor starts worrying about losing. And many times they'll offer you a much better deal or even dismiss the case rather than risk going to trial with incomplete evidence. But here's the other side of the coin, and this is equally important. If they can produce all that documentation, now you know exactly what evidence they have and exactly what you need to attack. You're not going into court blind. You're not guessing. You know their entire case. You know what the officer wrote in their notes. You know what device they used. You know when it was last calibrated. You know whether the officer was properly trained. And that information becomes your weapon to tear apart their case piece by piece. Now we get to jump into what I call evidence attacks. These defenses use that golden ticket discovery I just gave you as ammunition to destroy the prosecution's proof. This is where you attack leg number 2 of that stool, the reliability and admissibility of the speed evidence itself. Defense number 5 focuses on calibration records, and this is absolutely huge. Here's what most people don't understand. Radar guns and LiDAR devices are not magical truth-telling beams from heaven. They're tools, they're machines, they're electronic devices, and just like any tool or machine or electronic device, they require regular calibration, proper maintenance, detailed documentation, routine checks, and operator training. When you submit that golden ticket discovery request I gave you a minute ago, that packet of evidence the prosecution sends you should contain several critical things. Calibration dates showing when the device was last tested for accuracy, maintenance logs documenting any repairs or adjustments, the device's serial number so you can verify the records, actually match the specific unit used on you, technician signatures certifying the calibration was done properly, and documentation of required testing intervals showing the device was tested as often as the law or manufacturer requires. How do you win with this information? Simple. If any of those records are missing, if they're outdated, if they don't match the serial number of the device that was actually used on you, if they're incomplete in any way, you stand up in court and you argue that the speed readings are fundamentally unreliable. What exactly would you say? You'd look at the judge and say, Your Honor, I object to the admission of the speed evidence due to insufficient foundation. The calibration and maintenance records are missing, expired, or inconsistent with the device allegedly used. You see the difference here? Like most people walk into traffic court and argue, Judge, I wasn't speeding, I wasn't going that fast. That's a losing argument because it's your word against the officer's word. And judges almost always believe the officer, but you, because you requested that golden ticket of discovery, can now make a completely different argument. You're not arguing about whether you were speeding. You're arguing that the police don't even reliably know what speed you were going. You're arguing that their measuring device can't be trusted. That's a winning argument. Which brings me to defense number 6, and this one absolutely destroys cases all the time: operator error. Picture this scenario. You're sitting in moderate traffic. You start driving down the road. There are multiple cars all around you. Some are ahead of you. Some are beside you. Some are behind you. The police officer is sitting on the side of the road with a radar gun. They point it at the general flow of traffic. The radar picks up a speed. But which car did it actually measure? The officer has to make a judgment call. And very often they pick the car that looks most guilty to them. Maybe it's the sports car. Maybe it's the car with out-of-state plates. Maybe it's the car with a bumper sticker they don't like. The point is they're guessing which car the radar actually measured. Now, what if the police officer took no notes about the traffic conditions? Even better for you. Now, when they testify in court, they're essentially making up details on the witness stand because they don't actually remember what happened 3 months ago when they wrote your ticket. Here are some absolutely devastating cross-examination questions you can ask the officer to expose operator error. Officer, how many vehicles were in the vicinity of my vehicle when you took the speed reading? Officer, how far away were you from my vehicle when you measured the alleged speed? Officer, what lane was I traveling in? Officer, what was your angle relative to my vehicle when you aimed the radar? Officer, how did you confirm that the speed reading displayed on your device was from my car specifically and not from another vehicle? Officer, what checks or tests did you perform on your radar device before you began enforcement that day? Officer, what checks did you perform after my stop to verify the device was still working properly? If the officer's notes are vague, or if the officer admits they didn't take detailed notes at all, you have a golden opportunity. You look directly at the judge and you say, Your Honor, the state's evidence does not reliably connect the radar reading to my specific vehicle. There's insufficient foundation to prove that I was the vehicle measured. That plants reasonable doubt. That wins cases. But wait, what if the officer claims they didn't use radar or LiDAR at all? What if they say they used a completely different method called pacing? That brings me to defense number 7. Pacing is when a police officer follows behind your vehicle, matches their speed to your speed, looks down at their own speedometer, and uses that reading to determine how fast you were allegedly going. The entire reliability of this measurement depends on 2 critical factors: whether the patrol car's speedometer is actually accurate and whether the officer followed their training properly when conducting the pacing. This brings us right back to that golden ticket discovery request. Your evidence request specifically demanded documentation about the patrol car's speedometer calibration or certification, and it demanded the officer's notes about the distance and duration of the pacing procedure. Now, you can use that information during cross-examination. Here are the killer questions. Officer, how long did you pace my vehicle? Officer, at what distance behind me were you traveling during the pacing? Officer, do you have any documentation proving that your patrol car's speedometer is accurate? Officer, when was the last time your speedometer was tested or calibrated? Officer, were there any hills, curves, or traffic interruptions during the pacing? Officer, did you maintain a constant distance behind me during the entire pacing period? If the police provide no documentation about speedometer accuracy, or if they're vague or uncertain in their testimony, that's when you strike. You look up at the judge and you say, Your Honor, pacing evidence lacks sufficient reliability without documentation of speedometer accuracy and proper pacing conditions. The evidence is insufficient to prove speed beyond a reasonable doubt. But maybe you're sitting there thinking, wait a minute, Jeff, what if I was actually caught in what I think was a speed trap? Can I use that? This brings me to defense number 8. And yes, you absolutely can use your state's speed trap rules against the police. Some states have very specific legal restrictions on speed enforcement methods. Some require updated engineering and traffic studies before police can enforce certain speed limits in certain areas. Some prohibit the use of radar in specific zones without proper signage. Some require minimum distances between speed limit signs and enforcement areas. If you submitted your golden ticket discovery request, you should specifically demand documentation about the exact enforcement method used and whether it complied with your state's speed trap laws. Request copies of any traffic engineering studies. Request documentation showing proper signage. Request proof that enforcement was conducted in a legally authorized manner. What if the police were sloppy and can't produce this documentation? That's when you look at the judge and say, Your Honor, I'm challenging the admissibility of this evidence because the enforcement method used does not comply with applicable speed trap requirements under state law. But here's my warning. Be very careful with this defense. If you cannot explain the specific speed trap law clearly and cite the exact statute, do not lead with this argument. Only use it if you've done your homework, you have the actual law printed out, and you can point to exactly how the police violated it. Don't just throw around the term speed trap without backing it up, because you'll lose credibility with the judge. Which brings me to one of my absolute favorite defenses that the vast majority of people completely overlook. Bad signage. This defense can be incredibly powerful if it applies to your situation. Go back to the area where you were pulled over. Look carefully for the speed limit signs. Are they properly placed? Are they visible from a driver's perspective? Are they blocked by trees, bushes, or other obstructions? Are they missing entirely? If the speed limit sign is hidden, missing, faded, and unreadable, or simply not visible from where a reasonable driver would be, you can argue there was no fair notice of the speed limit, which means you cannot be guilty of knowingly violating it. This is exactly why you need to carefully review the police officer's notes from your golden ticket discovery request. Many officers will write in their notes that speed limit signage was properly posted and visible. Your photographs from the actual scene, taken from the driver's point of view, can directly contradict that claim. In fact, one of the single most effective pieces of evidence you can bring to court is photographs taken from the driver's perspective. Go back to the location. Take photos from the same position on the road where you were driving. Take them from the same angle. If possible, take them at the same time of day under the same lighting conditions. It's incredibly persuasive when you can show a judge or a jury that no reasonable person in your exact situation could have possibly seen the speed limit sign. What should you say in court? Stand up and say, Your Honor, the speed limit signage at the location of the alleged violation was not reasonably visible to drivers. I have photographs taken from the driver's viewpoint that I'd like to submit as evidence. When the judge looks down at you and asks, Did you see a speed limit sign? You look right back and say, Your Honor, all I saw was a tree blocking where the sign should have been. But what if the police officer didn't use radar, didn't use LiDAR, and didn't pace you? What if they just used what I call the I could tell argument? In some jurisdictions, police officers are actually allowed to use visual speed estimates as a legal basis to write you a speeding ticket. They'll testify something like, based on my training and experience, I could tell the defendant was traveling approximately 70 miles per hour in a 55 mile per hour zone. This is when you need to attack the conditions and the complete lack of reliable documentation in the officer's notes. If the officer's notes are vague or non-existent about the circumstances of their visual estimate, that's going to help you tremendously. Here are effective cross-examination questions for this defense. Officer, from what distance did you make your visual speed estimate? Officer, what were the lighting conditions at the exact time you made your estimate? Officer, were there any obstructions between your position and my vehicle? Officer, were there other vehicles near me that might have affected your perception of my speed? Officer, what specific training have you received in making visual speed estimates? Officer, when was the last time you were tested on the accuracy of your visual estimates? Officer, what is your documented accuracy rate for visual speed estimates? If it becomes clear that the officer was merely operating from a hunch or a gut feeling rather than any objective, reliable evidence, you look at the judge and say, Your Honor, a visual speed estimate under these conditions is insufficiently reliable to prove my speed beyond a reasonable doubt. The state has not met its burden of proof. Now, maybe you're sitting there thinking, okay, Jeff, this is all great, but what if I actually was speeding? What if I was legitimately driving 100 miles per hour in a 70 mile per hour zone? I can't deny it. What do? This brings us to what I call the yes but defenses. These are legal justifications that admit you were speeding, but argue you had a legally valid reason. Defense number 11 is known legally as necessity. This is not, I was running late for work. This is not, I really wanted to get home. Necessity means there was an immediate risk of serious harm, and the emergency you were responding to was greater than any potential harm you could have caused by speeding. Think about scenarios like your wife is in labor in the passenger seat, someone in your car is having what appears to be a heart attack, you're fleeing from an immediate threat to your safety, a child in the car is choking or having a severe allergic reaction. These are necessity situations. If this applies to you, present clear evidence of the emergency. Bring medical records if someone went to the hospital. Bring witness statements. Bring any documentation that proves the emergency was real. Then make your argument clearly and don't muddy it with other excuses. Say, Your Honor, I was responding to an immediate medical emergency. My wife was in active labor and we were rushing to the hospital. I have hospital admission records showing she gave birth 30 minutes after I was stopped. That's necessity. That can work. But you might be wondering, what about a bathroom emergency? I really had to go. Does that count as necessity? Be very careful here. This does not qualify as legal necessity in any jurisdiction I'm aware of. If you stand in front of a judge or a jury and say, the reason I was speeding is because I really had to use the bathroom, there is an extremely low chance they will ever accept that as a valid legal defense. It's not life-threatening. It's not an emergency that justifies endangering others. However, to possibly receive a more lenient result, a reduced fine, or a diversion program, it can sometimes be marginally effective, but only if you frame it very carefully and humbly. For example, I once saw someone who was cited for going 20 miles per hour over the limit stand in front of a judge and say, Your Honor, I take full responsibility. There's no legal justification for what I did, but I want to explain what happened. I had a severe medical stomach issue and desperately needed to reach a restroom. The only reason I was speeding was to get to the next gas station as quickly as possible. I made a poor decision and I apologize. Now, I don't necessarily recommend this approach because they basically confess to speeding without any valid defense. But I also watched the judge show mercy. The judge gave that person a deferred disposition with a reduced fine so that if they completed a defensive driving course, the entire ticket would eventually be removed from their driving record. Sometimes honesty and humility work in your favor for sentencing, even if they don't create a legal defense. But what if you were speeding specifically for safety reasons? When I say safety maneuvers here, I'm talking about brief speed increases to avoid immediate danger. Here are some examples. An aggressive driver tailgating dangerously close behind you, another vehicle swerving erratically near you, creating a collision risk, an unsafe merge situation where speeding up prevents a crash, debris, or an obstacle in the road requiring quick evasive action. This defense can work if your speeding was brief, proportionate to the actual risk created, and you return to a safe legal speed as soon as the danger passed. But be prepared, because a smart judge will likely look at you and ask, well, why didn't you just pull over to the shoulder and let the dangerous driver pass you? That's when you need to be ready with a good answer. You need to say, Your Honor, there was no shoulder available on that stretch of road. There was no safe place to pull over. I was trying to reach the next exit ramp so I could safely pull off onto a side road. As soon as I reached the exit, I immediately reduced my speed. The key is showing that speeding was the only reasonable option to avoid a greater danger. Here's what you could say in court. Your Honor, I briefly increased my speed to create a safe buffer distance from an immediate traffic hazard, and I returned to a safe, legal speed as soon as the hazardous situation passed. That's your safety maneuver defense. But what about the classic defense everyone tries? Judge, I was just going with the flow of traffic. If I was driving the speed limit, I would have gotten run over by all the other cars. This brings me to the flow of traffic defense. And let me be brutally honest with you, it's really not a legal defense at all. It's basically a myth. Judges hear this argument 50 times a week and they're completely tired of it. The legal speed limit is the legal speed limit, regardless of what everyone else is doing. You're responsible for your own driving, not for matching traffic. However, and this is important, if you use a dash cam in your vehicle and you're able to show clear video evidence that you were traveling at the exact same speed as the entire flow of traffic around you, it can be extremely effective for one specific purpose: impeaching the police officer's testimony. This works particularly well if you go back to that golden ticket discovery we discussed, and the officer's notes claim you were driving significantly faster than other vehicles, or if their notes are completely unclear about which specific vehicle they actually targeted with the radar. Your dashcam footage showing you matching traffic speed creates reasonable doubt about whether the radar even measured your car. And finally, what about the defense of passing another vehicle? In some states, the traffic code actually explicitly allows a limited, brief increase in speed in order to safely pass another vehicle on the roadway. But watch out, because in other states, increasing your speed above the posted limit to complete a passing maneuver can only serve as a reasonableness argument for mitigating the punishment, not as a complete defense to the charge itself. The only way this defense works in those particular states is if your increase in speed was brief and temporary, it was done for legitimate safety reasons to complete the pass quickly, and you immediately normalized your speed back to the legal limit after completing the passing maneuver. If that situation applies to you, you need to research your specific state's traffic code, find the exact statute that addresses passing, and quote it directly. Then look at the judge and say, Your Honor, I only briefly accelerated to complete a lawful passing maneuver safely, and I returned to the legal speed limit immediately after completing the pass in accordance with state traffic code section. But finally, when all else fails and you're desperately searching the internet for advice, there's actually some extremely bad advice out there telling you to use certain strategies that are not just ineffective, but are actually traps. These strategies will make things dramatically worse for you if you try to pull them in front of a judge. I'm going to give you 2 defenses that don't just fail, they'll make the judge want to throw the book at you as hard as legally possible. Trap number 1, sovereign citizen arguments. Things like, I don't consent to this court's jurisdiction, or I'm not driving, I'm traveling, or I'm a free man on the land. I hate to be the one to tell you this, but this absolutely does not work. It has never worked. It will never work. It irritates judges. It wastes court time. And in fact, many times it results in the judge wanting to make an example out of you by imposing the maximum possible fine and refusing any kind of leniency or reduction. And trap number 2, the argument that The constitutional right to travel means there are no traffic laws. I've heard many people claim that because the Constitution guarantees a right to travel, speed limits and traffic regulations don't apply to anyone on public roadways. The reality is that, yes, courts do recognize a general constitutional right to travel, but that absolutely does not mean you can travel however you want without any regulation whatsoever. The right to travel doesn't mean you can drive 100 miles per hour through a school zone. It doesn't mean you can ignore traffic signals. It doesn't mean you're exempt from safety regulations. Instead of making arguments that you already know the judge will never accept, bring actual documents. Request that golden ticket discovery. Come to court ready to attack the evidence professionally and intelligently, because here's where most people lose their cases, and it happens before they even make a single legal argument. The moment they walk into the courtroom, they start talking. They walk in nervous and they can't handle silence. They walk up to the clerk or the prosecutor and they start making small talk. They say things like, it's really not that big of a deal. I was only going a few miles over the speed limit. Everyone speeds on that road. Congratulations. You just did the prosecutor's entire job for them. You just confessed to speeding on the record. So here's the ironclad rule that will save you. When you walk into that courtroom, do not volunteer any information. Don't guess. Don't explain. Don't narrate what happened. Don't make small talk with the prosecutor. Just sit quietly and wait for your case to be called. When the judge asks, "How do you plead?" you look directly at the judge and you say clearly, "I plead not guilty, Your Honor." That's it. Nothing more. Now, if you know after watching this entire video that none of these defenses realistically apply to your situation and you just want to get rid of your ticket with minimum damage, here's what you do. Never plead guilty. Instead, ask about diversion options, ask about traffic school, ask about deferred disposition programs. These are programs that allow you to pay a reduced fine, complete a defensive driving course, and then get the entire case dismissed and removed from your driving record so your insurance rates don't skyrocket for the next 3 to 5 years. Most courts offer something like this for first-time offenders or people with clean driving records. The bottom line is this: fighting a speeding ticket is absolutely possible. Winning is absolutely possible. But you have to be smart. You have to be prepared. You have to request that golden ticket of discovery. You have to attack the evidence instead of just claiming you weren't speeding. And you have to know when to fight and when to negotiate for a better deal. Now you have the knowledge. Now you have the tools. Now you know exactly what to say and exactly what to request. Use this information wisely, and good luck in court.